This is the, I don't even know what annual. This is the Constitution panel that we do every year. We've been doing it for about 7 or 8 years now through the Social Science Department with the political scientists here. Today we're going to talk about some various topics that are relevant. Defense of Marriage Act, that was just, part of it was overruled this summer in June. The Voting Rights Act, that was partially reversed again in June. And of course the Syrian conflict as well. So I'll introduce the panel in just a second. What I do want to do is remind you that you can register to vote here. And the clipboards are in the back with pens and everything that's available. We will file these. Student Congress will file these for you. And this will get you registered in time to vote for the November election. There is a federal election coming up in November. There is a federal election on even years, the first Tuesday after the first Monday in November, every 2 years. So this fall, it will be for Congress and a third of the Senate. So
Not this one.
The fall 2014.
what?
This is an odd number here.
Oh, ignore me. Yeah, I'm on TV. Sorry. This will be not recognized unless you sign both times. You have to sign twice and date twice, or else they will not register you to vote. So please make sure that you sign and date twice. Okay. Great. Now with that good start that I had, are you sure you want me to have the microphone? I'll go ahead and introduce the panel. I am Heather Richards. I teach political science and American constitutional foundations here at GRCC. I've been here since 2004, and came here from Western, and yeah, I love it here. Jan Bai has been teaching political science here since 1994. He teaches American government, Asian politics, international relations, and comparative politics. He came here from Texas Tech University. Gordon Vrshik
Yes.
has been teaching at GRCC since the fall of 2009.
Vršić.
We discussed this.
Let's have a debate about it.
Yes. He has advanced degrees in political science, international economics, and political philosophy from Central European University, the University of Amsterdam, Bowling Green State University, and Indiana University. So he teaches American politics, international relations, and political theory. We've got a great panel up here today, by the way. And last but not least, we have Keith Sinclair. Keith has been with us since 2002. He's been seen frequently on Channel 28, most recently interviewed about the conflict in Syria, which he will speak about today as well. He teaches government and international relations. He holds 2 degrees from Illinois State University. And while in graduate school, he interned in London, working as a research assistant for the member of the British Parliament. So we're going to go ahead and get started. Let's see. Should we start with the Syrian conflict or? Okay. So.
For those of you who aren't aware, I mean, there's a civil war going on in Syria right now between Bashar Assad, who's the dictator of Syria. He's facing a rebellion that he's been trying to put down for several years. Some in the United States Congress have called for intervention early on, like Senator John McCain. And President Barack Obama has been reluctant to get involved until recently, when chemical weapons were used by Mr. Assad, and the government have used chemical weapons against the rebels. Barack Obama, as president, has said that this was a red line that would trigger American military intervention, and he has made the case to the American public that we are within our rights to to militarily intervene and punish Bashar Assad and his government for the use of chemical weapons. Senator John McCain, in order to get his support, has wanted more than just a punishment. He's wanted a strike that would debilitate Assad's ability to not only perpetrate the same action, but also possibly to win the war. So President Barack Obama has insisted that he need not ask Congress for the authority to strike Syria. He believes that the United States, in signing on board to the Chemical Weapons Convention, which bans the possession and use of these weapons throughout the world, not only gives other countries that signed it, but also the United States, the ability to act. And since the U.S. Senate had to approve that treaty and ratify it, he believes that he's already received all the congressional authorization he needs to militarily act. For those of you familiar with the Constitution, you know that the Constitution gives Congress, and not the President, but Congress, the ability to decide when we go to war. But President Barack Obama is arguing that since the U.S. Senate ratified that treaty and Syria's use of that weapon, chemical weapons, is a violation of that, that's all the authority that he needs. Now, that said, President Barack Obama has said that although he doesn't need congressional approval, he's going to ask for it anyway, or he did ask for it anyway. And that's really opened up a whole can of worms politically for him. Like I said, some conservatives in Congress of both parties, Democrats who support Barack Obama and Republicans who have been calling for action, may be on board, but they wanted to see a little bit more than what Barack Obama was willing to provide. Of course, you also have Democrats and Republicans, members of both parties, opposed to any military intervention. So uniquely in American politics in recent years, instead of a Democrat and Republican argument, you've seen Republican fighting Republican and Democrat fighting Democrat over whether military intervention is a good idea. Now, President Barack Obama, after calling for a congressional rubber stamp of what he was planning on doing, basically pressed the pause button when Secretary of State Kerry floated an idea that the Russians have jumped on, and that is to pursue a new diplomatic initiative. The Russians, I remind you, are backing the Assad regime. And the Russians have said that they can get Assad to give up his chemical weapons. Now, Barack Obama, as president, seems fit to allow that initiative to proceed. And he then asked Congress to postpone the very vote that he called on until that initiative had been exhausted. And one could argue that maybe he also wanted to postpone that vote because he also thought he might lose that vote in Congress. So, you know, here we are commemorating the writing of the Constitution, or the signing of the Constitution on this day back in 1787. Clearly, in the Constitution, Congress is given the approval, or the right to decide when we go to war. I guess it's an open debate on whether or not Barack Obama is correct in his assessment that the signing of this treaty and our international commitments under it allow us to act without a congressional declaration of war. You know, it is true, as many have pointed out, that there's been no joint resolution actually using the words declare war since the Second World War, and yet we've had many wars since then. I would argue that that really is a semantic smokescreen, that really the congressional authorization for the use of force can say it in just that way. It doesn't actually have to use the words declare war. Frankly, those words are considered needlessly provocative in the modern era, if not outright politically incorrect. For the United States Congress to pass an authorization as a declaration of wars does sound a little needlessly provocative if war can be avoided, and we do claim to go to war as a last resort. So I don't think any of us can really expect that any future authorizations of military force will say it in any other way than what I just said. I mean, don't look for such resolutions to actually spell out, we declare war. I just don't think that's going to happen in the future. And to me, it's the same thing. I mean, an authorization of military force, I think, is the equivalent of declaring war. And so when President Bush Sr. got that approval from Congress when he invaded Iraq in 1991 to exercise, get Saddam Hussein out of Kuwait, I think the Constitution was abided by. When his son, President George W. Bush, invaded Iraq in 2003, he also, prior to doing so, got Congress to authorize the use of military force. And even though I thought that was a huge mistake, both voting for that resolution and actually invading Iraq, I do at least concede that President George W. Bush followed the Constitution in getting the congressional approval prior to his invasion of Iraq. The current case is a little bit more problematic. I mean, if it's a missile strike, if it's an airstrike, we get down to the question of when is it a war? What defines a war? How many people have to die? Some people say, well, if 1,000 people die, then that's when it's a war. Some people suggest that because it's airstrikes and a missile strike, and there's no actual boots on the ground per se, that's not a war. If President Barack Obama were to put ground troops into Syria, I think it would be much more problematic, and I think then, congressional approval is probably required, but he could probably get away politically with a missile strike or an airstrike without seeking such authorization. With that, I guess I'll invite my colleagues to weigh in on your comments on this subject.
Well, in 1787, this day, September 17th, the Constitution, 55 delegates were there at the convention, but only 39 people signed the Constitution. So from day one, the Constitution was not agreed upon by all the delegates. Some just left because they didn't agree. So for the Congress has the power to declare war, but the President has the power to make war. United States has fought about 200 wars. Only 5 of them were declared by Congress. So how come we still fought war? Because Congress passed a resolution to authorize the President to use force. So in this case, President does not need the Congress to take action, but somehow he still asks Congress to give him approval. In my opinion, President Obama is just using Congress to get out of the dilemma which he made by himself, because he made a remark. He said, if chemical weapon was used, that would be crossing the red line. And he made this statement off the cuff, very casually. So I think if Congress has to declare war, that's not the war. And Congress will never declare war in this kind of situation.
I would like to make a little segue to voting rights, because voting rights was one of the issues that the Supreme Court debated in the past term. The story about voting rights in the United States basically begins, I think, with the creation of the Republican Party in 1854. In 1854, the Republican Party started as a political party based on the platform of freeing slaves. And freedom from slavery was basically the defining political platform, the defining political issue that Republican Party wanted to achieve. The three amendments in the Constitution that deal with votes of minorities, especially African Americans, are 13, 14, and 15 amendments. 13 amendments, all three of these amendments are post-Civil War amendments. So if you look at amendment number 13 in the Constitution, amendment number 13 abolishes slavery. Amendment number 14 establishes a number of things, but one of the most important things in amendment number 14 in section 1 is so-called equal protection clause, which basically says that all people in each state should be equally protected by the laws of that state. And then you have amendment 15 in the Constitution that basically explicitly gives the voting rights to those who didn't have them before, which basically meant slaves and African Americans and other minorities. American Indians were treated separately. Why did then Republican Party want to have votes of African Americans? I think the consensus among political scientists is that the Republican Party wanted to have votes from African Americans, and therefore they basically pushed through Congress and through the whole ratification process these amendments, because they understood that if they do not have, in the long run, votes of African Americans, they will never be able to preserve their congressional majorities in the long run. Democratic Party at the time, during the 19th century, were so-called Dixiecrats. Democratic Party in the 19th century was a party that supported slavery. Democratic Party was the one that supported slave owners. So a Democratic Party was the one that didn't even think of giving the African Americans right to vote, despite the fact that the Democratic Party is the oldest political party in the world, not only in the United States, but the oldest political party in the world. However, these three constitutional amendments, 13, 14, and 15, are actually toothless if they are not enshrined in the federal law, right? Because if certain things, if certain issues are not enshrined, they're not regulated by federal or state laws, right, then the federal government or state government cannot enforce them. Right? I mean, Supreme Court can say whatever they like, but Supreme Court does not really have any kind of enforcement mechanism. There's no Supreme Court police to knock on your door and say, you are not implementing the Constitution. That doesn't exist. Right? So the only way in which the Supreme Court can enforce Constitution is to rely on the executive branch of the federal government. And in order for the executive branch to implement certain things from the Constitution, there has to be a federal law. So the federal law that for the first time in American history gave equal rights, equal voting rights to everybody was the Voting Rights Act from 1965. Voting Rights Act explicitly forbade discrimination in voting based on race. Voting Rights Act also had two very important sections. The section 4B from Voting Rights Act basically created the formula according to which, the formula that determined what states and other areas in the United States discriminated against African Americans in the past. And then the section 5 basically determined that these areas in the United States that in the past discriminated against African Americans, that these areas need to ask for something called preclearance. Preclearance from either Attorney General of the United States or Congress whenever they want to change some rules of voting in their areas, right? Usually there were 9 states in the South. They were subject to preclearance. And because South, as most of you know, has a pretty strong history of discrimination against African Americans. Jim Crow laws, right? Jim Crow laws, which basically imposed poll taxes, which imposed literacy tests on African American voters. These were all state laws that basically prevented many African Americans from voting. Right? So this preclearance requirement said that whenever a state or an area in the United States subjects to that preclearance, whenever they want to change something in their voting rules, for example, if they wanted to introduce voter ID requirement, right? If any of these areas in the United States wanted to introduce the requirement that every voter has to show an ID at the ballot, right? They have to ask for permission from either Attorney General or Congress to do that. I don't know if you know, but 2 of these areas that have history of discrimination against African American voters are right here in Michigan. Clay Township in Allegan County, close to where we are, and Buena Vista Township in Saginaw County, on the other side of the state. These 2 townships in the state of Michigan were also subject to so-called preclearance requirement, which means whenever they wanted to change rules for voting, they have to ask permission from Congress to do so, or from the Attorney General. Right? There are some other areas that people wouldn't expect, like, for example, Brooklyn and Bronx in the city of New York. They were also subject to preclearance requirements. So it was not only about the southern states, right? But it's also about the states also about certain areas in some northern states that had a history of discrimination against African American voters. So a few years ago, Shelby County in the state of Alabama wanted sort of to synthesize complaints of many conservative Republicans who kept arguing that things in the South have changed, that the South of the United States is not discriminating against African American voters anymore. That the Supreme Court needs to repeal or remove from the law this Section 4B that require, not Section 4B that basically said that there is a certain formula about how to determine which of these geographic areas require preclearance, right? Shelby County said, the things have changed. We are not racists anymore. The South is not racist. We are treating African Americans in our communities equally in terms of voting rights as anybody else. So, in the famous case of Shelby County versus Eric Holder is Attorney General of the United States. Shelby County essentially won. Because the Supreme Court looked at the voting data in the past few elections, and they said this formula that determines what areas in the United States need preclearance, this formula is dated. Justice John Roberts, who is the Chief Justice of the United States Supreme Court and who wrote the majority opinion, he basically claimed that fewer African Americans are registered to vote in the state of Massachusetts than in the state of Alabama. So he said Congress needs to come up with a new way in which they calculate what parts of the United States are subject to preclearance requirement. The Shelby County in the state of Alabama also wanted the Supreme Court to remove from the law the Section 5 that required preclearance, right? But the Supreme Court didn't want to do that. Just gave a task to Congress. They just said, look, Congress, what you need to do is to change the formula according to which the preclearance requirement is calculated. As long as there is an old formula, as long as you guys do not change the formula, this Section 4B is suspended, and therefore Section 5, which requires preclearance, is not applied, right? If you cannot calculate what areas of the United States need to ask for preclearance, then preclearance is not being implemented, right? So that caused a lot of political trouble, right? A lot of political debate, right? Democrats were criticizing the Supreme Court, saying, look, Congress is not in the position right now to change the formula, because there is so much conflict and polarization in Congress that Congress is not willing to do that right now. Right? And Democrats were also saying what Supreme Court did basically introduced the new Jim Crow laws, reintroduced discrimination of African Americans in voting rights. Why? Because they were saying, if certain things in the law work, if this formula worked in terms of increasing the voting participation of African Americans, then you have to keep it, right? You cannot just discontinue it. And, Republicans seized on the opportunity. Many Republican states understand, and there is a lot of research on that, but many Republican states understand that obviously most of African Americans, or around 98% of African Americans, vote Democrats. So many southern states seized the opportunity. And you will see in the first article of the Constitution that the states determine who is eligible to vote in each state. There is no federal law that says to states, these are the people eligible to vote, right? So many, especially the state, for example, of North Carolina, use this opportunity to change its voting laws, right? For example, the state of North Carolina abolished the possibility for early vote, right? The state of North Carolina abolished the opportunity for 17-year-old high schoolers to register to vote so that they are eligible to vote on their 18th birthday, right? The state of North Carolina also introduced the requirement for voters' ID. If you look at the research about voting patterns, you will see that the more people vote, the higher quantity of people vote in any elections, the more likely it is that Democrats are going to win, regardless of who these people are. And especially if you allow minority voters to vote, and you will see, if you look at the election data from 2012 elections, you will see that 97% of African Americans voted Democrats, 72% of Asian Americans, almost 70% of Hispanic Americans, all of them voted Democratic, and all of them are less likely to have voter ID, for example. And all of them are more likely to vote early. So the accusation that liberals and Democrats are charging against the Supreme Court and against these new rules of voting in some southern states is that Republican governors and Republican legislatures in these particular states are trying to prevent African Americans and other minorities from voting, because this prevention of African Americans and other minorities to vote means easier victory for Republican candidates and means easier victory for Republican presidential candidates in future elections. So this is the battle for the votes, right? A Republican Party established itself in 1854 on the platform of discontinuing slavery. Why? Because they needed the votes of African Americans, right? Today, Republican Party in southern states is trying to prevent this vote from African Americans, because now African Americans vote Democratic, right? Why the change? The change took place during the Kennedy and Johnson administration, right? Kennedy started the Civil Rights Act, but he was killed before he managed to finish it, right? But Lyndon B. Johnson, in the context of his program of so-called Great Society, he pushed through Congress Civil Rights Act in 1964. He pushed through Congress Voting Rights Act in 1965 that they just discussed, as well as Medicare and Medicaid, which were another parts of Great Society programs. So this is the state of the play right now.
Thank you, Gordon. Keith, or Yan, do you want to add anything to that?
I think Gordon covered it very well.
That was a segue?
Yeah.
How did we lose Syria out of that?
Would you rather go back to Syria, or do you want to talk about DOMA?
We can segue to DOMA. The Defense of Marriage Act. This raises interesting interpretations of the Constitution. I mean, for many years, it was the states that had the sovereign right to determine who could marry and who could not in their states. And the Constitution clearly lays out a federal system of government where the national government is sovereign on some issues and the states are sovereign on others. And marriage was one of the ones that states were sovereign over. And yet, also in the Constitution is what is known as the Full Faith and Credit Clause, where states will, in essence, recognize each other's contracts. And marriage is a contract. I mean, for many, I'm well aware that for many, marriage is a religious experience. Maybe it's a romantic experience, but it's also a contractual experience. It is a business contract. And you are not, at what point in the marriage ceremony are you married? It's not when the minister pronounces you man and wife. It's not when you kiss the bride. It is, in fact, when you sign the contract and it is witnessed. The most romantic part of the ceremony, I'm sure. But it's the most important part of the ceremony. And if you haven't signed that piece of paper, no matter how beautiful the ceremony, you're not really married. But states like Michigan have refused to allow same-sex partners to marry. Yet Michigan also does not allow first cousins to marry. And yet some states have allowed first cousins to marry. It is actually a world norm for first cousins to marry. And if you married your first cousin in, say, the state of Kentucky and moved to Michigan, Michigan recognized that contract. Even though you couldn't have gotten married here, the fact that you got married in Kentucky meant that it was automatically recognized in Michigan. And yet Michigan has been claiming, under the Defense of Marriage Act, that they don't have to recognize other states' marriages of same-sex partners. I find that a striking inconsistency. So from the very inception of the law, when the law was passed by Congress and signed by President Bill Clinton in 1996, the Defense of Marriage Act said that not only was the federal government not going to recognize same-sex marriages, but they were also, the states themselves did not have to recognize same-sex marriages occurring in other states. Congress, even then, was anticipating states like Massachusetts, which would be the first state to allow same-sex marriages. So basically, it was giving states the added legal reinforcement that they needed, it was thought, not to recognize other states' marriages. Well, this last year, we found out in a new Supreme Court ruling that they at least struck down that portion of the Defense of Marriage Act that the federal government did not have to recognize it. So now the federal government does recognize same-sex marriages. And even if you're in a state, if you got married to a same-sex partner in a state that allows it, and then you move to Michigan, apparently you are now, according to the federal government, going to be able to at least claim or file for under your jointly under federal income tax forms. And that's interesting because the state of Michigan now still doesn't recognize the gay marriage, but the fact that these two men or two women were married in another state that did will allow them to file jointly their federal income tax forms. You know, it's going to make the state of Michigan look more and more petty over time. And it's kind of a pity, from my point of view, that the Supreme Court didn't take that opportunity to also strike down the other portion of the Defense of Marriage Act, which provides this pretense that states don't have to recognize other states' marriages. I think it's just a matter of time before the Supreme Court does strike that portion down. And I just think that the Supreme Court is rather cautious in how quickly and how much change it wants to adopt all at once. But I think states like Michigan's stance against gay marriage, I think those days are numbered. And I think that gays married in other states, living in Michigan, filing joint federal income tax is going to even make those numbered days even fewer. So, I've always thought that the Defense of Marriage Act was unconstitutional, and I think step by step we're getting to that conclusion with the help of the Supreme Court.
For those who don't know what the acronym DOMA means, DOMA is the Defense of Marriage Act, which was passed in 1996 by Congress. The definition of marriage, according to Congress, is the traditional union between a man and a woman. That's marriage. So if it's a union between a man and a man or a woman and a woman, that's not marriage. Now, on the 26th of June this year, past summer, the Supreme Court said, well, that's not so true. But in my reading, the Supreme Court does not establish a constitutional right for the same-sex marriage. What it says is withholding the benefit for the spouses is unconstitutional in those states where the marriage of the same sex is legalized. So what I want to say is that same-sex marriage is a right, but it is not yet recognized by the Supreme Court as a constitutional right.
Yeah, the Supreme Court had the opportunity in one of these two cases. There was one case that was about federal benefits in gay marriages, which is United States versus Windsor. But there was a case about California Proposition 8. I don't know how many of you know that, but in 2008, a group of anti-gay marriage activists put the proposition on the ballot during the November presidential elections and congressional elections, put a proposition on the ballot that asks voters to decide whether they would like to ban the gay marriage in the state of California. Before that, the gay marriage in the state of California was legal. So majority of California voters decided that gay marriage should be banned. Some political scientists are saying, well, this is because Obama was running for election, so many African Americans came to the ballot in order to vote for Obama, but many African Americans are also very socially conservative, and therefore that's what basically tipped the balance against gay marriage in a very liberal states such as California. But what happened was that a group of pro-gay marriage activists hired themselves to two famous lawyers, Ted Olson and David Bain. One is a staunch Republican, another staunch Democrat, right? They hired themselves to excellent lawyers who basically wanted to argue before the California Supreme Court that this particular Proposition 8 deal was totally unconstitutional. Right? It is unconstitutional because of the 14th Amendment, Equal Protection Clause, right? Equal Protection says that all people in each state should be equally protected by the laws of that state. So that implies if rights of straight people to marry are protected by state laws, therefore, why isn't that rights of gay people to marry are not protected by state laws? The same argument that was used to give African Americans right to vote, right? That's also how pro-gay marriage activists framed the issue of gay marriage. They frame it as a new civil rights fight. And now they're framing the issue of immigration as a new civil rights fight, which means civil rights for the minorities. Gays are a minority, immigrants are a minority, illegal immigrants are a minority, and African Americans are a minority, right? And yeah, just a moment. And then what happened is that Supreme Court then decided, well, we are not going to decide on really Proposition 8, right? Why? Because the state of California refused to defend itself before the Supreme Court. The state of California said, we are not going to defend Proposal 8, despite the fact that state of California was sued because of the Proposal 8, right? But the new governor, Jerry Brown, who is very liberal in the state of California, said, we are not going to defend Proposition 8, right? So on the other side of the argument was not the state of California. On the other side of the argument against gay marriage was a group of anti-gay marriage activists, right? So the Supreme Court basically said, you guys, you anti-marriage activists, anti-gay marriage activists, you don't have a standing in this case because the decision by the Supreme Court is not going to influence your lives in any way, right? I mean, in order to have a standing in a court case, your life has to be influenced in some way by the decision of the court in the case, right? So since Supreme Court decided not to decide on Proposition 8 case, the lower court decision stood, right? And the lower court, which is the Ninth Circuit Court of Appeals, decided that Proposition 8 was unconstitutional, which basically meant that the state of California, but only the state of California, could resume gay marriage, which it did just a few hours after the Supreme Court decisions, right? But Supreme Court had a big opportunity here that they didn't want to take. The Supreme Court had the opportunity to basically legalize gay marriage on the federal level, right? They could have said Proposition 8 is unconstitutional, therefore any law similar to Proposition 8 is unconstitutional based on the Equal Protection Clause, and therefore all states in the Union have to legalize gay marriage, but they didn't want to do that. I think why? My interpretation is that they didn't want to get themselves into the same kind of discussion as abortion. In 1973, in Roe versus Wade, essentially, Supreme Court by its decision legalized abortion on the federal level. And that basically created a huge political debate between proponents and opponents, right? I think what Supreme Court wanted to do is to stay back and said, okay, we are not going to do the same thing as we did with abortion, right? What we are going to do is let the states sort it out, right? So the states are now basically trying to decide whether to legalize gay marriage or not, and while at the same time the federal government recognizes federal benefits for the people who are married in the states where gay marriage is legal, no matter where they live. Even if they live in the states where gay marriage is illegal, the Supreme Court is saying as long as you were legally married in the state where gay marriage is legal, you will be going to receive federal benefits, Social Security, Medicare, Medicaid, immigration benefits, and so on and so forth. So I find it fascinating, actually, that the Supreme Court didn't take this opportunity, didn't take the opportunity to legalize gay marriage on the federal level. They just sort of said, no, it's not our job to do that, right? They just said, let the states sort it out and see what happens. So that's the state of play, right? They are allowing the states to think about it and to see whether they wanted to do or not. But I think this is not over. I think that there will be another case about gay marriage, and there will be another case, and then Supreme Court will again have the opportunity to either legalize gay marriage on the federal level or not. We'll see what happens. But I think the pressure for federal legalization is going to continue.
Okay, Yan, did you want to jump in?
I was about to say that the issue at heart is whether the government can regulate marriage or not. If yes, at which level? Federal government or state government? I mean, federal government defines marriage, but state governments do regulate. Like, in your marriage, how many spouses? Cousin. So they do regulate marriage. But we all know marriage is your right, individual right. But how far can that right go? So I think that's the first issue. The second issue is marriage comes with responsibility. It's not just a right. Everybody has right to get married, but do you have the responsibility to keep your marriage? So in that case, on the 26th June this summer, the Supreme Court reaffirmed the part of responsibility. You are in the marriage, that's a contract, and it's up to you to live up to the responsibility. So that should be emphasized too, along with right. Every right entails responsibility.
My question is, so if the federal government is acknowledging the marriage to the point that people are able to file joint income taxes or receive benefits, how is that not the federal government recognizing marriage? Gordon?
I think it is. What Supreme Court basically repealed from Defense of Marriage Act from 1996 is definition of marriage, right? I mean, the DOMA, Defense of Marriage Act, the law passed by Congress, defines marriage as a union between one man and one woman, right? Supreme Court said, why is that? Why should that be the definition of marriage, right? So yeah, I think it is a redefinition of marriage. By the way, why it is that Bill Clinton, who was fairly liberal president on social issue, why is it that he pushed Congress through pushed DOMA through Congress in 1996? It was because many conservative Republicans in the Congress were clamoring for passage of a constitutional amendment, right, that would define marriage as a union between one man and one woman, right? So what Clinton wanted to do is to sort of satisfy these conservative Republicans, saying, okay, let's not do the amendment stuff, right? But let's pass a law that would basically require that would define marriage as one man and one woman. But if you think about the spirit of the Constitution, the spirit of the Constitution in most cases, not in all cases, but in most cases, in most amendments, is expanding the rights of individuals, not constraining their rights. Right? However, many conservatives are also afraid of a slippery slope argument. Why wouldn't then you allow some other kinds of marriages, right? Why wouldn't people get married with animals? Or why wouldn't people get married with certain siblings, right? You can say, well, incest. What if two brothers get married and so on, right? I mean, that's what that's what some conservative Republicans are basically talking about. So it is still a complicated issue, and I think that the Supreme Court wanted to stay away from legalizing. Because of that, the Supreme Court wanted to stay away from legalizing it on the federal level.
Another incentive that Bill Clinton had in 1996 was that he was up for re-election that year, and I think he thought passing the Defense of Marriage Act would solidify more support amongst mainstream Americans at that time period to help him get reelected, which of course he did quite handedly.
Okay, I'd like to open the floor up for questions from the audience on any of the topics that are covered today. I think we've addressed a lot of these issues quite.
Can I just add a little bit to the same-sex marriage? The DOMA, that act that was passed in 1996, was based on the notion that marriage was about procreation. You gotta have marriage that can produce children. Now that notion that notion has been passed or overcome, so we don't emphasize procreation. Now, again, that decision says, well, it's not about creation, it's also not about sex, it's about relationship. So in my opinion, it's like, how do you define marriage? It seems to me, every time we got a hot issue or hard issue, we cannot solve, we just legalize. How many things have been legalized? We have legalized smoking cigarettes. That was not good before. We have legalized alcohol. We have legalized marijuana. So now we're talking about legalizing same-sex marriage. So how far can we go? So that's my concern.
Okay.
Yeah.
I really do want to get to some questions here.
Sure, I'm one of the Board of Trustees here attending this session, and it's a good session. I haven't come to Constitutional Day yet. This is our first time. But I had a question on Syria, one point of that the President made about the using of chemical weapons. He wanted to strike at them for using that. And I don't, and also that he's afraid that if he doesn't, that chemical weapons will be used more and more, and even against our own soldiers. Do you care to comment on that point a little more?
The question is, does, you want to know a little bit, you just want me to elaborate a little bit more on the President's position on that?
Yeah, and what do you think about that main point about chemical weapons? That was part of, really his main issue was he didn't want chemical weapons to be used, and he thought he'd make an issue out of that to stop it in the future. Or
He's been very reluctant to do anything really to get involved in Syria. I mean, many have called for him to do more, and he's refused up until this point. And really, it's taken Bashar Assad's use of chemical weapons, and many would point out that this last time was not the first, that he's
Right.
done it several times over the course of the year, but finally it just became unavoidable to address the fact that he was using chemical weapons to the point of embarrassment, some would say. And so the President has felt the need he drew a red line earlier that implying that if chemical weapons were used, the United States would intervene militarily or as a punishment or something more. And so he kind of felt he felt the need to comply with what he had said before. And if you want to know what I think personally, I've been very supportive of that. It's really two issues for me. I mean, on the one hand, I was one to like to see U.S. intervention much earlier in support of the rebels to unseat Assad. President Barack Obama seems unwilling to go that far. But I personally believe that the civil war in Syria is destabilizing the region, potentially our ally on the border, which is Turkey, not to mention Israel, which feels threatened by it. And, I feel like the next step is really the ethnic cleansing. And are we going to really be able to stand by and watch that happen? So I think we have a very real interest. We're pledged to defend all NATO countries. Turkey is a NATO country. It's on the border of Syria. Those borders we're pledged to defend. Can we really stand by and watch a country implode like this with now the use of chemical weapons, with potentially ethnic cleansing? I would have said get involved earlier. All right, we didn't. But now that chemical weapons have been used, I also feel like this is a horrible precedent for the future. It's really incumbent upon the United States to kind of lead the way in punishing in some way or showing how this is inappropriate behavior, that we're not going to settle for this. Because if we do settle for chemical weapons being used, and we just look the other way, and we let it be known that this is okay, then we're going to see other countries using them. And that means potentially in the future against the United States military, against U.S. civilians. I mean, the world is a scary place already. Do you really want to be required to carry gas mask around with you in your car because a terrorist got their hands on some chemical weapons and now they're so freely available, anyone can use them? I don't want to see us living in that world. I really do think that the use of chemical weapons needs to be taboo. It's horrendous that they've been used as much as they have been, and I don't want to see Assad get away with it. And I know the argument that there's rebels who are affiliated with al-Qaeda, but those aren't the only rebels in Syria. It's a real mishmash. It certainly is ironic that the United States and al-Qaeda are on the same side on this one. along with Israel, who also wants us to do something militarily. All three seem to be in agreement that they want to see Assad go. Who would have thought so shortly after September 11th that al-Qaeda and the United States would have a common goal? But there we are. So President Barack Obama is talking about surgical strikes, and now he upped it when he was talking about maybe strikes that might debilitate the Assad regime. Russia's adamant that that not be the case. Russia's a strong defender of the Assad regime, and they're not going to let their ally go under without a diplomatic struggle. So, this proposal to get rid of all chemical weapons by Assad, if Assad actually does it, I'm all for it. But it seems like it could be a long time before that's confirmed.
That was actually one of my questions earlier, is according to this agreement that Russia and Syria came up with, Syria is going to give up their chemical weapons to Russia? Is that
Well,
the
presumably
understanding?
they're going to destroy them. Russia's not allowed to have chemical weapons, nor are we.
Ones that have been providing the chemical weapons to Syria.
No,
That's what, and
they may have provided the materials to make the chemical weapons, but Russia would be in full violation of the Chemical Weapons Convention if they actually possessed and used them as well.
Well, the Chemical Weapons Convention was held in 1996. Now, one of the clauses says you have to dispose, you have to eliminate your stockpile if you got chemical weapons. Now, how many countries have chemical weapons today, currently? Syria, U.S., Russia.
No, the United States does not have chemical weapons.
U.S. has chemical weapons.
Just a little bit, not as much as it used to.
Wow, a lot, a lot.
just a wee little, just a little.
The United States was signed on board to the Chemical Weapons Convention because we didn't need chemical weapons, and we were willing to give all of ours up. And
Do we know absolutely for sure that we don't have chemical weapons?
We do have them.
I'm not the.
So, Yen, tell us why it is that you believe there are chemical weapons.
From what I have read, yes, we have chemical weapons. Russia has chemical weapons, in Syria, and another two countries. No, we
Iran.
haven't eliminated our stockpiles.
The United States has eliminated stockpiles, at least ostensibly. We do not have chemical or biological weapons in the United States. We purposely gave up those weapons with the intent that all other countries do the same, precisely because we had the ace in the hole, the nuclear weapons. We don't have chemical and biological weapons. We haven't invested in them because we have a better weapon. It's called a nuclear weapon. And as long as we're allowed to have nuclear weapons, the United States is on record as trying to eliminate chemical and biological weapons everywhere in the world.
Okay.
According
Next
to-
question, please.
According to the treaties that the United States signed, it was supposed to eliminate all of its chemical weapons by January 1st of this year. And one of the methods that the United States has been using is to load up big ships with chemical weapons, just sink them to the bottom of the Atlantic Ocean. So there is a lot of stuff on the bottom if you're interested. But
Thank you.
but according to the United Nations, the last report of the United Nations that I read just a few days ago in the context of Syria, United Nations estimates is that United States has eliminated 89% of its stockpiles that it had in 1955, which was the peak of American possession of chemical weapons. So we still have it, but only 11% of the United States, what the United States used to have. That's at least according to the United Nations.
And one of the sources is The Economist magazine that has an article
Oh,
on that.
okay.
So the weapon of mass destruction, there are three kinds: chemical, biological, and nuclear. United States has all of them.
Next question.
Don't ask a chemical question.
Next topic, I should say.
Sorry. Oh, sure. Sorry. This is in part for anyone in my class who is trying to answer the questions I gave them to answer as coming to this presentation. Goes to judicial philosophy. And we talked about gay marriage, abortion was mentioned, war powers. On the judicial right, the court, 4-1-4 divided court, 4 of those judges, Republican appointees, would say that they're originalists. They want to focus on the original meaning of the Constitution, that they would look at the Constitution and say, there's nothing there that gives, for instance, right to abortion or to gay marriage for that matter. Now, what judicial philosophy, how would you describe a philosophy that says, no, gay marriage is supported in the Constitution or abortion is supported? How do you describe that philosophy and what would you call it? Is there a name for it? For the 4 other judges on the court or for yourselves, if you have an opinion on judicial philosophy?
The originalist interpretation of the Constitution, I'm adamantly reject. I mean, if we're going to read the Constitution as it was originally written and intended, and it was written by people who supported the institution of slavery, that allowed for the institution of slavery in the Constitution. When Scalia brings up this idea of originalist argument, I just think it just sounds so batty. The idea that you're going to read that document as it was intended to be written in 1787, I think it's impossible.
I disagree. I disagree. I think that you can read the question about marriage as an originalist in the Constitution. And that is that it was not enumerated or expressed. It was not expressly given to the national government, and therefore, through the 10th Amendment Reserve Clause, it's left to the states. That's the originalist intent. That's what the framers intended. And so this question put before the court about whether or not gay marriage should be recognized is not based on originalist intent of the original 7 articles in the first 10 amendments. It's based on the framers' intent, or it's based on, the Equal Protection Clause in the 14th Amendment. And the Supreme Court is looking at this standard in which they've applied throughout probably the last 40 or 50 years, and that is that similarly situated individuals must be treated equally. So 2 people perform open heart surgery, 1 goes to jail. They're clearly not a doctor and qualified to do that. However, when you're talking about 2 individuals of the same gender and treating those individuals who are tax-paying individuals, who abide by the laws, who participate in society, really no different than 2 individuals of a different gender. The question is there any legal justification? And keep in mind, we have to pull religion out of this. Is there any legal justification for treating homosexuals and heterosexuals differently? And that's the question that the court answered by declaring the part of the federal law unconstitutional that said that the federal government cannot recognize same-sex marriage. That the federal government will recognize same-sex marriage. And you earlier stated that the court didn't go so far as to strike down what the states are allowed to do. And that is, I think, because of the conservative court, they feel very strongly that this is originally a state matter. And that if states want to strike down or provide for same-sex marriage or not provide for same-sex marriage, it's up to the states to do that. So I think that is actually Roberts deciding in line with the original intent of the framers, and that is, this is a state matter. However, since the federal government weighed in to this issue and made a law in 1996, now we have to evaluate the law based on current social circumstances, and 2 individuals of the same sex cannot be treated differently than 2 individuals of different gender by the federal government. But they can't tell the states what to do. Not yet. Not yet. I sense you have a counter argument.
Not a counter argument, but I guess I want to extend the question again. Like, I'm curious. There's an originalist philosophy. You say you don't like it. How do you describe your philosophy, and do you have a name for it? Or how do you think the other end of the court would describe their philosophy, and would they have a name for it?
I mean, I guess the name of my philosophy is activist. And I'm sure that's what Scalia would ascribe to it.
Well, remember, activists and restraintists are not ideological based. There can be conservative activists. We've certainly seen that out of Scalia when it comes to gun control, right? And we've seen activists on the liberal end coming out of the Warren Court in the 1960s. So restraintists and activists aren't necessarily tied to a particular ideology. But I think what he is
What name would
asking-
you ascribe to it?
You're asking what his ideology would be. How he would describe his own opinion.
The other half of the court. I raise it because when I try to describe this in class, the best term I've come up with that I've seen people use is living constitution. Living constitutionalism. And that, to me, that's an acceptable term. That's fine. But I haven't seen it used a lot by people who it's ascribed to. So I'm kind of curious if you have a different term, if you'd use a different term. And I think you said, someone said progressive maybe, or activist, or
I don't have a
how
problem
do you
with
define it?
Any of those terms, really. Living Constitution, I would find that acceptable. Progressive, I would find that acceptable. Activist, I don't have a problem with that.
I've often seen it referred to as a textualist as well, that you look at the actual text of the law, the Constitution, or whatever it is that you're looking at, and what does it literally say? And the Equal Protection Clause literally says.
Does the Constitution mention marriage?
No.
So I think, yeah. So I think to explain to students what's going on here, because this is becoming a pretty
Semantic argument.
semantic argument. Yes, there are two philosophies in understanding how Supreme Court makes this decision. One is originalist, which basically says that yes, Supreme Court justices need to look at the original text of the Constitution and the writings of the people who wrote the Constitution, ideologically at least wrote the Constitution, and another school is saying, well, that Constitution is a changing, living thing, and therefore we need to be able to somehow adapt it to contemporary circumstances. I have a proposal about what you're asking. I have a proposal, constructivist, right? Constructivism is a postmodernist philosophy. It's a philosophy that is also widespread in sociology and perhaps anthropology, which says that there's no objective truth, that in order for us to understand how the world works, we need to construct the truth that explains how it works. I think constructivist philosophy of constitution could be one way of understanding this notion that the old documents such as Constitution is adapted to contemporary circumstances. So constructivist is my proposal. To construct the truth rather than, or interpretivist, right? To interpret what the Constitution wanted to say rather than to claim that it's possible to see it both from the Constitution and from the writing of philosophically inclined founding fathers, such as in Federalist Papers, for example. Right?
Okay, we only have about 5 more minutes left. So at least for Keith to be on the panel, he has to run to class.
Well, Neil, I mean, in my opinion, I think that's originalism because the Supreme Court actually left the power to define marriage to the states. And traditionally, states had that power to regulate union, marriage. So I think original. And actually, the Supreme Court did not establish any constitutional right to the same-sex marriage.
Does that help? Sort of. Any other questions? Okay.
I have a question about the reversal of DOMA. is it possible that if we get a Republican in the office next time, that this would flip-flop and we would go back and forth with these kinds of decisions?
It's possible. I don't see it likely.
Why not?
Well, because you're giving people rights and then you're taking them away. I mean, to me, it's like giving 18-year-olds the right to vote and then 5 years later taking it away from them. I mean, that's a pretty fundamental right. I mean, once given, politically, I think it's very difficult to take it back.
Yeah. I mean, it is always possible for Congress to pass a new law that would perhaps do the same thing as DOMA. Right? And it could perhaps define the marriage in a different way that would not necessarily also include gay people. Right? So, but is that likely? I also agree with Keith very much so. It is not likely. I think that the United States public opinion already passed this threshold of majority of Americans approving of gay marriage, and you have a bunch of Republican senators, for example, who also approve of gay marriage, such as Rob Portman from Ohio, Lisa Murkowski from Alaska. Plus, there is a fairly strong stream of libertarians right now in Congress, and some of these libertarians in the Republican Party would like to run for president. People like, for example, Rand Paul, right? Rand Paul would like to run for president. He may not agree with the legality of gay marriage, but he also doesn't think that government should be involved in regulating marriage. So I think the United States has already passed this threshold, so I don't foresee that some kind of conservative revolution that would return us back to the times of DOMA would have any chance of succeeding.
Okay, we have one more question.
Just a few words. Now, it depends on what right we are talking about. If it's natural right, no one can take away, because natural rights are the right at your birth. Just because you're a human being, you have certain rights. Government cannot take them away. But if it's a legal right, government can take them away, because legal rights are conferred by the government. Now, Kennedy in that case said, liberty is the right to define your own existence.
My name is Matt Hofste. I was with Jan's class this summer. You talked about the Voting Rights Act that got removed. However, you talked about the items that was put into the North Carolina law that they put in for the different parts of their law. However, most of those parts are what most of the northern states already have. So how can we say to one state that we're going to say you have to have a voter ID in a northern state, but in a southern state, you don't have to have a voter ID. How is that fair under the Equal Protection Law?
Equal Protection Clause in the United States Constitution is about states, right? So if all people in a certain state, in every state, all people in certain states have to be equally protected by the laws of that state, not by the laws of the federal government, right? So if a certain state, for example, allows straight people to get married, that means that according to the interpretation of the Supreme Court, it has to allow gay people to get married, right? Because this is the right protected by the law of that state. If you look at the first article of the Constitution, you will see that eligibility to vote in elections is determined by the state. It's not determined by the federal government, right? So as soon as this state who were the subject to pre-clearance in the Voting Rights Act, as soon as these states do not have to submit right now pre-clearance to change their voting laws, they can do basically whatever they like, whatever their legislature pass, and the federal government cannot do anything about it, right? So it's about states. Equal Protection Clause is about states. If you read Equal Protection Clause, it says every state should, right? So that means that every state should basically equally protect all of its citizens by its laws, right? But doesn't say that there is some kind of a federal law that should equally protect all citizens of that state.
I just had a question. It's kind of a history question. You mentioned the beginning of the Republican Party, and just for history, and then you said the Democratic Party was the oldest. Now, you go back to the beginning, if I remember my history, there were the Whigs and the Federalists, and then Thomas Jefferson was a Democratic Republican Party.
Yeah.
Now, can you just give a little information for the people on how those parties split up, or, the names and what they represented a bit?
No, it didn't split up. I mean, the Republican Party is not coming from Democratic Republican Party, right? Democratic Party started as Democratic Republican in 1796. That makes it the oldest party in the world, right? And it was established by Thomas Jefferson, right? Why it is that Jefferson used the term republic? Republic is opposite to monarchy, right? So monarchies are countries that are ruled by kings and queens, by the royal families, and republics are supposedly countries that are ruled by the people, right? Res publica in Latin means public thing, right? It belongs to everybody, right? Of course, when Jefferson thought about res publica, he didn't mean women or he didn't mean minorities, right? So he meant mostly white men with some kind of material possessions, right? So Republican Party is not a party that's split from Democrats, Republicans. Republican Party is the one that basically established itself independently. What is interesting about Republican Party that established itself in 1854, and then we have the first Republican president, Abraham Lincoln, after that, right? What is interesting about Republican Party is that a Republican Party was the third party, right, at the time, right? Does anybody know who were the other two parties, of Democrats and? No, they were not independent. That's right. Democrats, Whigs, and Republicans. So Whigs were the second party, and Republicans were the third party in terms of being the smallest party. And one of the political science laws is that whenever you have something called single district plurality system, right, of elections, which is basically winner takes all system. That's how elections in the United States work, right? Only one candidate from each district wins and goes to Congress, right? If you look at, for example, European elections, in Europe you don't vote for candidates in particular district, you vote for a political party, and every political party that gets, for example, in Germany, 5% or more of the votes, their representatives go to the parliament, right, depending on what is the proportion of the vote they received, right? So because in the United States we have single district plurality system, which means that only one member from one winner from each district goes to the House of Representatives, right? That usually in political science means that such system produces only two major political parties, right? There is no chance for third parties because people don't want to waste their vote on the third party. They either vote for one or the other because they understand that the third party doesn't have a chance to win. But Republican Party overcame these odds, right? Republican Party was the third party in a single district plurality system. It didn't really have a chance of becoming a long-term major political party, but it still did. Why? Because they captured this burning issue in 1854, which is slavery, right? Why did they want to free the African Americans from slavery? Because they needed their votes. That's what politics is all about. You basically don't do it necessarily for humanitarian reasons, right? Republican Party didn't really think that freeing African Americans from slavery was a morally great idea, right? They thought that basically freeing African Americans for the purpose freeing African Americans from slavery was great for the purpose of getting votes. Look at the immigration debate, right? The immigration debate right now in the United States is again about votes, right? Democrats would like illegal immigrants to have path to citizenship. Why? Because citizens can vote, right? Republicans would not like illegal immigrants to have path to citizenship. They would like them only to achieve some kind of green card, right? Why? Because they think that most of illegal immigrants who get citizenship will vote Democrats, right? So it's always a struggle about votes. Social change in the United States or any other society around the world is struggle for power, struggle for votes among different groups of people in this society, right? In American society, people are presented by two major political parties, Democrats and Republicans, and they try to promote policies that would gain them votes, right? Democrats are trying to promote reproductive rights of women, their gay marriage and so on and so forth. They want to, Obama, even before elections, came up with the executive order that change for a better the way in which student loans are being repaid. He he came up with basically helping so-called dreamers, illegal immigrants who came here before the age of 16. Why? Because he needed their votes, right? So all of these arguments about winning votes, and I know it sounds very cynical, but all of these arguments about winning votes from both parties are always enshrined in some kind of moralistic or moral reasoning. Why? Because nobody is going to like your policies if you come to television and say, look guys, we are doing this for you just because we need your votes. Of course you have to say something else, right? So if you think about history of American politics or history about any other political society, always ask yourself who benefits, who wins, right? This is the way in which politics works. Who benefits, who wins.
No, the Democrats traditionally were for the state rightists. They were pretty much in the South, so they were very conservative. The Republican Party emancipated the slaves. Now it's kind of reversed. Now Republicans are conservative today and Democrats are liberal. So there is a party realignment in the past.
So why it is that Kennedy and Lyndon B. Johnson wanted to push for the civil rights laws that basically gave African Americans voting rights on the federal level? Because they needed African American votes, right? If you look at the voting data, before 1960s, majority of African Americans voted Republican because they perceived Republicans as their protectors. Now you look at the voting data and you see 98% of African Americans voting Democrats. Why? Obviously because they perceive Democrats as their helpers, right? So it's always a struggle about votes. All these debates about immigration, gay marriage, all of that stuff is just a struggle for power. It's just a struggle for votes. That's how politics works. That's what it is. Don't let anybody else tell you differently.